signed.
Wow. Ladies and gentlemen, welcome to our talk on the Roberts Court sophomore year. This is the first in a series of lectures of Practical Politics and the Law, sponsored by the Program in Public Law and the Journal of Constitutional Law and Public Policy. I'm Julian Yap, and along with Sarah Hawkins, we are the speaker series editors for this year. Our speaker today really needs no introduction, but I'm going to give one anyway. Ken Starr is Dean and Professor of Law at Pepperdine University School of Law in Malibu, California. He is also of counsel to the law firm of Kirkland & Ellis, PC, where he was a partner from 1993 to 2004, specializing in appellate work. Dean Starr formerly taught constitutional law as an adjunct professor at New York University School of Law. He was also a distinguished visiting professor at Chapman Law School in Orange, California, and George Mason University School of Law, where his legal scholarship was directly responsible for their remarkable performance in the 2006 NCAA Men's Basketball Championship. Dean Starr published his first book, First Among Equals, The Supreme Court in American Life in 2002, which has been described as not just the best treatment to date of the court after Warren, it is likely to have that distinction for a long time. As Solicitor General of the United States from 1989 to January 1993, Judge Starr argued 25 cases before the Supreme Court. He served as the United States Circuit Judge for the District of Columbia from 1983 to 89, as counselor to U.S. Attorney General William French Smith from 1981 to 83, and as law clerk to Chief Justice Warren Burger from 1975 to 77, and Fifth Circuit Judge David W. Dyer from 73 to 74. Judge Starr was appointed to serve as independent counsel for 5 investigations, including Whitewater, from August 1994 to October 1999. Having received his BA from George Washington University in 1968 and his master's from Brown University in 1969, Judge Starr graduated with his JD from Duke Law School in 1973, where he was note and comment editor of the Duke Law Review. He was formerly a partner with the law firm Gibson, Dunn & Crutcher, LLC. Judge Starr has numerous professional affiliations, including having served as president of the Institute of Judicial Administration, as well as the Council on Court Excellence. Other boards on which he serves or has served include Advocates International, the American Law Institute, American Judicature Society, Supreme Court Historical Society, the American Inns of Court Foundation, Institute for United States Studies, American University, Shenandoah University, and the American Bar Association Journal Board of Editors. He has received numerous honors and awards, including the Jefferson Cup Award from the FBI, the Edmund Randolph Award for Outstanding Service in the Department of Justice, and the Attorney General's Award for Distinguished Service. We are honored to have such a distinguished and accomplished practitioner and scholar to kick off our speaker series. Ladies and gentlemen, Dean Ken Starr.
Thank you. Wonderful. Thank you very much. Thank you. Thank you for that very gracious introduction, and it is great to be back at the Duke Law School. We spent 3 very happy years here, and Alice, my bride of 36 years, actually received a degree from Duke, which was charmingly called the PhD degree, Putting Hubby Through. So she too has a degree from this great institution. Well, today is a very sacred day. It's a holy day. It's Yom Kippur, the Day of Atonement, which happened to fall unusually this year on the first Monday in October. By law, the Supreme Court of the United States, as many of you know, if virtually all of you know, must in fact begin its new term on that first Monday in October. And here it is. Now, because of Yom Kippur, the court came in this morning, just 2 hours ago, and announced the conclusion of the prior term, OT 2005, and announced the beginning of the term OT 2006. The court then simply recessed. No oral arguments held today, and so the first oral arguments will begin tomorrow. Of course, at the center seat for the second year in a row was the new Chief Justice, who, of course, the nation has now come to know through the confirmation hearings last year. And we know that what is now the Roberts Court became the Roberts Court by virtue of the very tragic passing of the Chief Justice of the United States, William Hubbs Rehnquist, who had served going back to 1986 as the Chief Justice of the United States and who fought very bravely a terrible disease that finally took his life, notwithstanding his courageous stand and his gritty determination to continue judicial service, which he loved so much. One of the very intriguing ironies of the fact that the Chief Justice of the United States has now stepped into the center seat is that he was serving as a law clerk to Chief Justice William Rehnquist at the very time that the person whom he was to succeed, Sandra Day O'Connor, came onto the court in 1981. Then law clerk John Glover Roberts Jr. was just winding up his clerkship, his year, and about to begin a tour of duty at the Justice Department in the Reagan administration, and then on to his White House counsel service, and then a very distinguished career, as many of you know, in private law practice at Hogan and Hartson, a very renowned law firm in Washington, D.C., where in fairly short order he, the Chief Justice, began heading the appellate practice, coupled with a tour of duty when we served alongside one another in the Solicitor General's office when he was serving as Deputy Solicitor General. And by the time he had concluded his career and was nominated to his private practice career and was nominated to the United States Court of Appeals for the District of Columbia Circuit, in which he served for 2 years before his elevation to the center bench, he had argued 39 cases in the Supreme Court of the United States. Now, that's just not just one of those utterly irrelevant numbers. I would like for you to just reflect on that for a moment. The person who is now the Chief Justice of the United States had the opportunity and privilege, and call it training, to argue in the court where he now presides recently think about 39 moot court appearances, but then think of 39 different cases over the span of decades that began in the 1980s, then his dominance in the 1990s, and then on into the early part of this century, within no lesser authority than Ruth Bader Ginsburg saying, John Roberts is the best. So think of the combination not only of great experience, not exactly unparalleled, but virtually unparalleled, experience of a number of arguments on behalf of the government as the Deputy Solicitor General, many more arguments as a private practitioner, doing what? Your own Professor Walter Dellinger has given voice to this in a curtain raiser that the two of us did in Washington, D.C. last week, which I thought was extremely insightful, and it gave voice to the sentiment that I much less artfully tried to describe. What Professor Dellinger said at this curtain raiser before the press in Washington, D.C., looking ahead to the first Monday in October, was, there is perhaps no one, and I'm paraphrasing here, who has had the combination of background skills training to step into that center seat in the history of the Republic. Because to try as a lawyer to develop and refine and present a position that will in fact persuade 5 members of the court is a very unusual art form. Only a handful of people do that sort of thing. Now, to his credit, our new Chief Justice has a wonderful sense of humor, and he tells the story on himself and one of his cases in private practice. And we say in litigation, there are really 2 things. There are victories, and then there are developments. Well, John Roberts, private practitioner, had a development. The case, and I forget which case it was, but whatever it was, he lost the case 9-0. Now that's humbling, that's embarrassing. You never like to lose a case, but to lose it, and that happens. And when it does, it's just, you've crestfallen doesn't begin to describe the feeling of emptiness and hollowness inside. I am an utter, colossal failure. And you know, the client feels even more strongly. Why did I hire that person? I could have hired, Walter Dellinger. So the client is being informed of the number of votes, and the client is incredulous. 9-0. I really don't understand. I mean, you went through all this preparation, we had these briefs. You lost not even a single vote. Not 9-0. How could you lose 9-0? John Roberts, because there are only 9 members of the court. You have to do what you can. The point, John Glover Roberts Jr. is incredibly equipped to do what? Be a very significant Chief Justice of accomplishment, given his obvious intelligence. Okay, he didn't go to the Duke Law School. We want to hold that against him, but he did have fairly decent training. We know from the confirmation hearing process that, oh my goodness, when he entered Harvard College as a 17-year-old, he was treated as a sophomore, and he proceeded, because of all of his AP courses, and he proceeded as a sophomore at the college, as an 18-year-old sophomore, to win the sophomore prize for the best essay of the sophomore class at Harvard College. This guy is really good. He's very elegant. And he also doesn't take himself all that seriously. So he's got Midwestern niceness, and so he's from Michigan City, Indiana, right? So if you're from Michigan City, Indiana, you can't take yourself that terribly seriously. So he's got a really balanced, integrated, lovely family, 2 beautiful adopted children. Jane and she are really great family people, so he's just an all-around kind of person. But he also brings a particular viewpoint, and here I'm not talking about politics, I'm talking about the traditions of the law. That viewpoint that he brings is that the court is doing its best when it tries to achieve the narrowest possible result in a case and thereby achieve as much harmony and concord and agreement on the court as possible. Now think of that. That the Chief Justice believes that harmony and concord is a good thing. And we can think as lawyers, as law students, as friends of the law, why that would be so. Stability in the law. A sense that law is not simply politics by another means and that people are just voting their political preferences. They are, in fact, being very lawyerly and taking the judicial craft very seriously, so that regardless of what one's worldview might be on a very controversial issue, say religion in the public square, say abortion, that we can in fact, the constitutional implications of abortion or end-of-life issues and the like, search and seizure questions, that we have actually come together as lawyers and we have found common ground. Not in a parliamentary compromise, let's split this down the middle, so instead of $2 billion, we'll all agree that it's $1 billion. But rather, we have found a principle around which we can all rally. Last year, his rookie year, John Glover Roberts succeeded at an epic level going back several generations. He, through his leadership, and obviously there are 9 very independent justices, and no one is just going to be a nice person to go along to make the Chief Justice feel good. They have taken an oath, and they take judicial independence very, very seriously. But in over 50% of the cases, the Supreme Court was unanimous, including in abortion. Remarkable. Including in a religion in the public square case. Including in a very hard-fought case involving whether law schools and the American Association of Law Schools could, in fact, given their objection to the Defense Department's employment practices with respect to gays and lesbians, keep Army, Navy, JAG recruiters off campus. If one read, as I did, the transcript of the oral argument in Rumsfeld v. Fair, F-A-I-R, the group of law schools that had come together to object to the Department of Defense's policies, one would have predicted that the court would have been somewhat cacophonous. And yet, speaking through the voice of the Chief Justice, the court was unanimous in sustaining the constitutionality of the Solomon Act that would have cut off funds to institutions whose law schools forbade Army, Navy, Air Force recruiters from recruiting on campus on an equal basis. How did it happen? How could the court be unanimous? Justice Alito was not yet on the court. In Ayotte versus New Hampshire, in an abortion case in the parental notification area. How could it have been unanimous in a religious freedom case where the court rarely has been unanimous, and you have to go back some considerable distance in time to find the equality principle in really deciding a religious freedom case on the basis of freedom of speech grounds, that you can't discriminate, you, the state, cannot discriminate against a religious voice in the public square. No preferential treatment, but no exclusionary treatment. The religious voice gets the same treatment, the same right of access. Other than that, the court has been completely and seemingly hopelessly divided when an issue of religious freedom has come before them. And yet here, the court, speaking again through the voice of the Chief Justice, 9-0 in the UDV case, rejected the government's position and had a very robust view of religious freedom as against the powers of the government. What is going on here? Well, I want to, before we open it up for conversation and discussion, and maybe say a little word about the upcoming term in the sophomore year. But to understand the sophomore year, which is just now unfolding, I think we have to at least pause and have a full appreciation of the triumph of what I think was a stunning performance by the Chief Justice and his colleagues. But I want to scroll back to the hearings just a little over a year ago, when then Judge Roberts was in the cauldron of what Professor Stephen Carter of Yale calls the confirmation mess. But if you watched the hearings or read portions, news reports of the hearings, you saw, you read that he requited himself very well. Again, extremely well prepared, no notes, right? Knew all the cases, could banter, have a pleasant conversation, sense of humor, self-effacing, brilliant, very articulate, all those great things. No one had, boy, I mean, everybody's saying, this is really impressive. This may be the best show of any nominee in the history of the Republic to anything. This is just spectacular. And those were from his enemies. His friends just said, well, there he is. He's just a violation of the too good to be true rule. All right, now in the course of those hearings, the chair of the Senate Judiciary Committee used as an example of what he thought was dreadfully wrong with the court the Ten Commandments cases, which had just been decided in late June of that year, of 2005. In the two Ten Commandments cases, the deeply divided, fragmented court, 5-4, split Solomonically, upholding the Texas State Capitol memorial display, a monument with the Ten Commandments displayed, among some 27 other memorials or monuments on the grounds of the Texas State Capitol. 5-4. It struck down 5-4 the display in McCreary County, Kentucky of the Ten Commandments inside the courthouse, not in a monument or in a memorial, but in a sort of plaque, the way you can just go up and you can read it as if it's a photograph or a print, and struck that down. And Chairman Specter now, it's 3 months later, is using this as essentially a powerful example of what is wrong with the court. There are all these concurring opinions and dissenting opinions. Can't they get their act together? My characterization. Chairman Specter would never be so disrespectful. But he did suggest that something must be wrong in terms of the process at the court if the court is so deeply divided so that the American people are left in a state of utter confusion. We don't get it. It's okay, but it's not okay? Is it something about Kentucky, the water in the Kentucky? Maybe it's bad in the mountains, but okay on the plains? The Alamo? I don't know. What is going on here? In fact, on his last public day on the bench, a stricken, valiantly fighting William Hubbs Rehnquist announced the judgment in the Ten Commandments cases. His last case is. He authored the plurality opinion, meaning he spoke for 4 but not 5, of the justices in the Texas Ten Commandments case. The 5th pivotal vote upholding the Texas memorial was Justice Stephen Breyer. In contrast, the same 4 who disagreed with the Texas memorial were in cheerful agreement with Stephen Breyer that the Kentucky display had to fall. And so here is Arlen Specter essentially scratching his head. And also in the backdrop was a very, very troubling poll that had just been issued, didn't get spoken of, by the Gallup organization. It was not tied to the Ten Commandments cases, but showed that the Supreme Court of the United States, and this is now 5 years after Bush v. Gore, annual polling, that in that year in 2005, the public confidence at the Supreme Court of the United States was at its lowest ebb since polling began in the 1940s. Public confidence was eroding even in the Supreme Court of the United States, and eroding below that after the wildly controversial Bush v. Gore, and obviously John Roberts wasn't on the court in Bush v. Gore, but the Chief Justice, deceased, was. It was in that context, with Arlen Specter saying, can't the justices work together and do better, that the Chief Justice of the United States said, and then he gave voice to this in his Georgetown graduation speech in May, some 9 months later, as the court was nearing the end, of handing down opinions in OT 2005. He suggested that the court had a duty not to find consensus in the sense of kumbaya, let us march together, but the duty to the law to find that narrow ground on which we can in fact come together and agree. And if you go back now and look in light of that performance, looking at the transcripts of the oral argument, I think that a fair and reasonable observer, laying politics and philosophical preferences to one side, will say, I think that there is, in fact, a new era here. A Chief Justice who is saying, what is the narrowest possible legal ground, but also one who also has given voice to, in a very important case from last term, which was not a unanimous case, which was the Vermont political contributions case, the Sorrell case. He joined in an opinion authored by Justice Breyer, who once again was the pivotal vote. Oh, that was a 6-3 opinion striking down the Vermont limitations as unduly intrusive into basic freedoms such as freedom of speech and freedom of association. That Vermont had gone too far in putting what the court found were unconstitutionally Procrustean limits on the ability of individuals to participate in the polity and the political process by making campaign contributions, or for candidates to be able to expend at reasonable amounts. Struck down 6-3. But in the opinion for the court in this particular arena, here was Chief Justice Roberts embracing Buckley versus Vallejo, the Fountainhead 1976 opinion, which has been in political contributions, political freedom, money in politics, and so forth. And he did so on the basis of stare decisis, that it has been the law, and I am going to be respectful of the law. So now the curtain raiser, and then let's open it up so we have lots of time for conversation and discussion. I'm sorry, my curtain raiser. If you'll hold off just for a second. And I was told, do not slap the microphone. I apologize to whoever ears is now badly hurting. The Supreme Court now has two extraordinarily, at least, controversial cases before it. One is the partial birth abortion case. The Partial Birth Abortion Act of 2003 passed by the Congress of the United States, along with 30 other states. But looming in the background is the court's 2000 decision striking down 5-4 the Nebraska statute. The case is called Stenberg v. Carhart. Nebraska passed a statute that forbade this particular methodology for the abortion procedure called D&X, or intact D&E, and forbade it criminally. And the Supreme Court of the United States said that must fall because, among other reasons, there were more than one, but the pivotal reason was no health of the mother exception was built in to the statute. Speaking through Justice Stephen Breyer, a very important member of the court, they're all important, but Justice Breyer, as in the Ten Commandments cases, was the deciding justice. I think we tend to say, oh, well, now that Justice O'Connor's gone, let's look at Justice Kennedy, and that's right. But I think we sometimes, as students of the court, neglect the potentially central role that Justice Stephen Breyer plays. Now we have, instead of a state statute and a one-day trial, we have a congressional statute with fairly detailed findings of fact, and in the findings of fact, the Congress of the United States has determined that this particular method of abortion, called pejoratively partial birth, but more, I guess, scientifically, D&X, or intact D&E, is never medically necessary. Very interesting finding, and gives rise to some very intriguing separation of powers questions, jurisprudential questions, that is, the ability of Congress to engage in fact-finding. And in its findings of fact, with respect to this very interesting and sensitive arena, Congress expressly invokes the jurisprudence of the court, in addition to findings in the abortion arena and women's health arena. It specifically invokes decisions of the Supreme Court of the United States in various areas, commanding the courts to give deference to Congress's superior fact-finding ability. So you see where we're going here, right? We now have Congress, not a single state, and I remind you of what Oliver Wendell Holmes Jr. said, that the republic would not fall if the court were forbidden from entertaining or reviewing, judicial review, acts of Congress. But the republic might fall, remember he was a veteran of the Civil War, if the court was not empowered under judicial review to review statutes passed by the states. And we all know as citizens that's the whole idea at the founding of the vast commercial republic. Madison's Federalist 10, beware essentially of boss hog. boss hog can get control of the operations of government, and law enforcement and the judiciary all can operate under the boss hog of a particular community, even a small state. A faction can achieve control and maintain control, whereas in the vast commercial federal republic, the factions are competing against one another, and it's very difficult for a single faction, the merchant faction, the farm faction, or the Silicon Valley faction, to seize and to maintain control. The genius of the vast commercial republic. Well, the genius of the vast commercial republic, of course, is embodied in we, the Congress assembled. We, the people in Congress assembled, as opposed to Nebraska. So you have that very interesting and rich separation of powers dimension. Do we, in fact, here in the abortion arena, want to pay the same kind of heed and attention to what Congress has done in terms of its findings, including a specific finding that no health of the mother exception is necessary because this procedure is never medically necessary? Very interesting. That's a stay tuned, very important case. The second, and then we open it up. Affirmative action. And the revisiting, perhaps, of some of the issues in the University of Michigan, famous affirmative action case where, of course, as we know, the University of Michigan Law School, very holistic approach to assessing the merits and the life story of each candidate on his or her own merits, on his or her own grounds, was upheld, with race background being taken into account as part of that holistic understanding of that individual's life story. In contrast, the University of Michigan undergraduate case did not, in fact, entail what we would just call in law school reading the files, looking at the files and coming to understand the files fully and completely. And now we have, and that was struck down, with Justice O'Connor being the pivotal vote, that you can't simply give credit to an individual on grounds of her race without more. You have to understand that dimension of the person's personality and humanity and dignity in story, holistically. All right, now we have two school districts, Seattle, Washington, and Seattle, Tacoma, and then Louisville, Kentucky, that are in fact taking race into account in terms of public school assignments in order to what? Maintain diversity. And one of the critical elements of the holding in that University of Michigan case is, at least at the higher education level, because of the portal door opening, career opening, opportunity opening, society participating nature of college education and higher education more generally, diversity is in fact a compelling state interest. Will that obtain at the public school level? Huge, huge issue. Stay tuned. I said that was the final. I'm going to open it up with this. Keep an eye on something that is truly below the radar, and that is, how busy is this court? Because the court, under Chief Justice Rehnquist, shrunk the merits document, not the certiorari document. You can't shrink that. If you lose a case in the Court of Appeals or the State Supreme Court, you can file a petition for a writ of certiorari. Thousands of them are filed every year, 7,000 to 8,000. That's a lot. But the court, under the leadership of Chief Justice Rehnquist, shrank the merits document, those that the court chose to hear, from approximately, round figures, 150 to approximately 70 to 80. And last term, the court set a record in his first year, Chief Justice Roberts' first year, hearing the fewest cases in modern history. Now, the Chief Justice said, I think we need to take more cases. Will they or will they not? Huge question to be answered. But I leave you with this thought. Whether you agree or disagree with a particular opinion, we now have with us a sophomore, John Glover Roberts, Jr., who is now the age of 51, who has already accomplished that which people didn't think could be accomplished, and that Arlen Specter, as the chairman of the Judiciary Committee, really wanted to be accomplished. can't we have greater unanimity and less cacophony, and thereby promote public confidence in the Supreme Court of the United States, which I think is a great and worthy goal. God save the United States and this honorable court. Thank you for listening, and I look forward to your questions. Thank you. Thank you.
You spoke about Chief Justice Roberts and his philosophy of a narrow ground for agreement as a way of achieving unity. And I'm curious about your reaction to critics who argue that this is actually an erosion of having three equal branches of government and a ceding of power to the executive and legislative branch by choosing to use the judicial power as weakly as possible.
Well, that's very interesting because it's equating narrowness with weakness, and I don't think that necessarily follows. And certainly the Supreme Court's decision last term in Hamdan, the constitutionality and legality under public international law of the criminal tribunals case, and striking down the Guantanamo criminal tribunal mechanism, suggests that there are pivotal times when this court will not hesitate to speak, and to speak fairly boldly, and even write broadly when it thinks it appropriate to do so. And that following on the heels of the Razul case, asserting jurisdiction, federal jurisdiction and power over Guantanamo, even though there was considerable law that suggested, in light of traditional formalistic public law principles, that because sovereignty continues to lay in the government of Cuba, that then federal judicial power did not run. But the court rejected that. Now, that was the year before the Chief Justice arrived. And in fairness, let me note that because he, the Chief Justice, had been a judge on the D.C. Circuit, which had Hamdan before it, and had ruled in favor of the government there, that he did not participate. So it was an 8-person court. But I do tend to think that this court, as a court, when there are issues of equilibrium in our government, and a sense, whether one agrees or disagrees, that there is a disequilibrium and a need to check the powers of Congress, which we saw in the Rehnquist court. You don't have to agree with this, but it clearly was the case. Speaking through centrist voices like Justice O'Connor and Justice Kennedy, that Congress had, in their considered judgment, gone too far in regulating arenas that were viewed as traditionally the province of the states, with no predicate, no stated predicate or nexus to interstate commerce so as to trigger the Commerce Clause power. And so it is now in the current age that we heard from Justice O'Connor previously, but and I think that equilibrium concern was hers as well. But Justice Kennedy, when one reads his separate opinion in Hamdan, one sees there the same desire on the part at least of that justice, who again is a very pivotal justice, to make sure that we maintain equilibrium as between what? The executive branch, the legislative branch, where is Congress in this process, and a kind of renewing the call for returning to the principles articulated by Justice Robert Jackson in his famous concurrence in the Korean War or conflict steel seizure case, the Youngstown case, where he identified this taxonomy of power and suggested that the President of the United States was acting at its lowest ebb of power when he was simply invoking his own powers as implied under the Constitution. Now, if you say, well, that's just George W. Bush, I would say go back and read Ron Chernow's book on Hamilton, because Hamilton was chuckling mightily when Mr. Jefferson decided in 1803 to do that which he felt was ultra vires. But he felt that the exigencies were such that for him to turn down Louisiana, 820, and not just the state of Louisiana, 828 square miles, so that the geographic territory of the United States would be expanded by, beyond wildest dreams for $15 million, as a distinguished historian at the University of Virginia put it. Very simple constitutional theory. Mr. Jefferson was a good real estate man. But he did, in fact, have a constitutional theory. He fretted that he had exceeded his constitutional powers, and he actually thought that he should maybe even seek a constitutional amendment. And he said, you know, that's just not going to work. So I looked to history, and I want a little bit of ratification from the Congress of the United States. So this is and the theory that he articulated was one of implied powers. So Mr. Hamilton, obviously a great proponent of implied powers, CEG, the Bank of the United States, felt, well, there they go. Once they become the chief executive and they're faced with certain executives, welcome to my world, as I was advising General Washington, to make the country run, or see Mr. Lincoln and the suspension of habeas corpus. But that's why the court sits. When those kinds of things arguably happen, and I think we have a court that is still seeking to affirm this enduring quality of equilibrium. Yes?
You spoke about public confidence in the court, which seems to me to be less reliant on the number of opinions in any given case and more reliant on the consistency over time of opinions, that people would have low confidence in the court if they change their mind about what's constitutional every couple of years. But the two cases you pointed out for this coming term, both, while in potential, could overrule very recent precedent from 2000 and 2003. And I wonder why, if the court is really interested in public confidence in the judiciary, they would even accept cases that question such recent precedent.
Wonderful question. And I think that the short answer is, let's just say the partial birth abortion case. I think when Congress passes a statute which is then struck down as unconstitutional, it would be rare in the extreme for the court not to determine whether the lower court got it right. So I would draw a very clear line as between a state statute on the one hand, and then a statute passed by Congress that's struck down as unconstitutional. There's no rule that says the court must do that. Every now and then, of course, Congress will in fact include a thou shalt review a judgment so that we bring about finality, perhaps even bypassing the Court of Appeals. It chose not to do that in the Partial Birth Abortion Act of 2003, which is interesting in and of itself. But I think that's the short answer, that as a matter of respect, call it comity between and among the branches. That law obviously was signed into law by the president, so INS versus Chadha, bicameralism in the presentment. So you have the political branches bicamerally and the president saying this is the law of the land, and now lower courts have struck it down. So I think that as a practical matter, that is why the court would almost always take a case where a statute has been struck down as unconstitutional. Now, the affirmative action cases raise richer issues, I must say. Here, of course, is an extension. Now, this is not the University of Texas affirmative action case, is it? This is, to the contrary, the extension of the University of Michigan diversity as a compelling state interest rationale down to secondary education. So is that so? I mean, if one goes back and examines the opinions, including the briefs and the oral argument, one sees a very strong focus in the University of Michigan cases on this portal opening dimension to higher education. Now one might say, well, good grief, if that's a portal, isn't public secondary education a portal as well? Absolutely, you need to have a high school diploma or its equivalent. But are these social concerns about, or state concerns in terms of diversity, do they ring as true, or are they as powerful in the public education setting? And in particular, here is, I think, a dimension that, as I understand it from the briefs, and I will admit, I've not studied this in depth. I'm going to, but I just haven't had the opportunity to study the briefs in depth. But part of what I think the submission is that children are different because this is compelled education. You see, okay, after the age of 16. But as a practical matter, it is compelled. There's nothing that's even informally coercive about a higher education, right? Bill Gates, okay, maybe his dad made him go to Harvard, but he said, I'm out of here. Okay, Michael Dell, maybe his dad said, and I gather he did, you got to go to college. But he was out of there after, before he had ended his freshman year. So you got Gates heading back to Seattle, Dell just then going back to his garage. Do you see what I'm saying? I don't need this. I've got an idea. So what are the arguments going to be with respect to secondary education? Are we, in fact, encouraging greater dropout rates by virtue of these kinds of mechanisms? And I think that's where the social science briefs, and they have been filed, will be of interest. Are you, in fact, disincentivizing parents to keep their children in the public school by virtue of race-conscious remedies that are causing children to go to a school other than their individual close to home school? You see what I'm saying? Lots of, I didn't mean homeschooling, but the neighborhood school close to home. So, but now having said all that, I think the very fact that the court has spoken so recently to the importance of diversity will certainly be a factor that will weigh in the judgment balance of each and every justice. It will not weigh that heavily with some, I think, especially if one were vehemently in dissent. And then I would then suggest the final thing that occurs to me is that the University of Michigan was 5-4. And you had the centrists divided, right? Justice Kennedy was in dissent. Justice O'Connor in the majority. So there's a certain, shall I say, instability to it, and then the fact that it is so recent suggests, as some justices would say, we've got to get it right. And if 4 of us disagreed and the issue is still popping up, we need to really thoughtfully reconsider. But your point about stare decisis and stability and public confidence, I think, is a very powerful one. I thought I saw a hand in the back. I did not see a hand in the back. Did I see a hand in the front? Do I hear a hand? Turn this into an auction. The dean has joined us. Dean, thank you, and thank you for your hospitality. Would you applaud your dean, who is such a wonderful leader. Any other questions? Yes.
You used the example of the 10 Amendments case as a potential for where the Roberts Court, instead of doing what they did, which was, uphold one and strike down the other, could find a narrow ground that they agree on. But in that example, I feel like upholding the one case and striking down the other case, the court actually made a very real distinction. And I don't know that I could come up with a better way of deciding those two cases. So I guess, following with that example, if you could maybe describe how...
I know class doesn't begin until 1:25 or 1:35, so keep going.
If you could describe how you see how the court could have done that differently, or how Roberts Court could have dealt with those two cases in a way that you feel like would have fit this model that...
Yes, and far be it for me to say that were I the law clerk, I could have given Chief Justice Rehnquist, so here it is, and we're going to have a unanimous opinion. And I don't at all underestimate the jurisprudential difficulty. But let me give you a very specific example. In his plurality opinion, Chief Justice Rehnquist invoked a tradition of history and tradition. George Washington's farewell address, his prayer for the American people, In God We Trust, the national motto, and the like. And he strung together a very, to me, impressive, by no means complete example of various ceremonial acknowledgments, obviously found in the Declaration of Independence, which set forth the American public philosophy, that, and as William O. Douglas said, and I just met with the Christian Legal Society gathering earlier, we are a religious people whose institutions presuppose a supreme being. Now, we believe in freedom of conscience. Doesn't mean you've got to believe. You don't. Welcome to a liberal democracy that protects, at its best, freedom of conscience assiduously. All right, with that. So that's the methodology that Chief Justice Rehnquist used in what turned out to be his plurality opinion. In his dissenting opinion, in that particular case, Justice John Paul Stevens said, and I'm very much paraphrasing here, Chief, this is the same methodology that you used in the case of Wallace versus Jaffrey, the Alabama moment of silence case in 1986. You did not take a majority of the court with you then. And you're not taking a majority of the court with you now. Ironically and cruelly, to his grave. In other words, that voice, that methodology had been re-articulated and restated by the Chief Justice for, count them, 19 years, and he had not taken the majority of the court with him. Now that suggests, and I mean no disrespect to the late Chief Justice, that that jurisprudential dog was unlikely to hunt. So why didn't you think through, and now I guess I am sounding critical, what is the methodology that could in fact, isn't there something that could bring us together, but I didn't even see him trying. He just said over again what he had been saying all along, and that didn't work. So now we have a Chief Justice who, fresh start, the law is the law, and so maybe in these kinds of ceremonial acknowledgments, he will be able, in fact, to emphasize something such as the fundamental Madisonian value of freedom of conscience. That as long as there is assiduous respect for freedom of conscience, there is no need to, I'm just suggesting this as a methodology, to expunge from the record of these Moses and the Ten Commandments, who's shown as one of the lawgivers in the Supreme Court of the United States, or throughout Washington, D.C. Washington, D.C. is pregnant with references in official documents to the Almighty. Could you, in fact, bring together a theory of ceremonial acknowledgement, but at the same time emphasizing freedom of conscience and not having to do obeisance to say, I believe or I don't believe, that you protect that assiduously? Would that have worked? I don't know, but what I do know is the old dog was brought out to the hunting ground and did not hunt. And I think what John Roberts is essentially saying is, can I find some method that will appeal to the, shall I say, libertarian, the freedom of conscience folks who at the same time are not going to vote. There's not going to be a vote to strike one nation under God. Because they know, regardless of what they feel, it's not going to happen. Because if they did, there will be a constitutional amendment like that, is my humble prediction. And they know that. And that's why the Michael Newdow challenge to one nation under God, full disclosure, I represent Sandra Banning, the mom in the case, who is in favor of the pledge. But she is in favor of the pledge of allegiance in a thoughtful way that protects freedom of conscience. I think working to find those kinds of enduring values, or as Justice Breyer said in his confirmation hearing, when he's presented with a problem, he likes to think of sort of what we would call first principles. What's kind of a first principle? In this whole religion clause area, it seems to me that at the foundation is, and this is in the Memorial and Remonstrance, penned by Madison and attached to Everson versus Board of Education in 1947, the path-breaking Establishment Clause case. That memorial is lifting what? Up the idea of freedom of conscience. Maybe something like that could have had a chance. Yes?
You've been speaking very favorably about the idea of garnering public goodwill towards the court's decisions by consent among all 9 justices. But, and since you're talking about the founders, isn't there a quote by Thomas Jefferson that dissent is the highest form of patriotism? And so isn't there something to be said that a justice who really believes that the court is mistaken should dissent to provide a rationale for the future in case public opinion shifts?
No question. History yields up different demands or opportunities as different chapters unfold. And so it is that we rightly honor the great First Amendment dissents of Holmes and of Brandeis at a time when there was, in fact, a real erosion judicially of something that's foundational, and that's the protection of the marketplace of ideas. So too, a year ago, we marked rather silently the centennial of Lochner versus New York and the magnificent dissents there of Holmes and the first Justice Harlan. The idea of self-governance and the judicial power being used in an overly muscular way to strike down the ability of people through their assembled representatives to have progressive era legislation. So we celebrate that justly. However, I think what has happened, and those are chapters that we honor. However, I think we have reached, and certainly this was the sense, and you don't need to by any means agree with this, but there is a sense abroad, and I think it's across partisan lines in the Senate Judiciary Committee, it certainly resonated with me, that could the justices work a little bit harder if there is common ground to be had to find it. If there's not, there's not. And I think Hamdan is a good example. There was no common ground there. And so the justices just allowed their voices to with various and sundry opinions. So we need to, of course, honor principle, and we want the justices to be true to their conscience and not to engage in conference room vote swapping, and that would be terribly corrosive of public confidence, but more than that, it would be unfaithful to their solemn duty to uphold the Constitution as their lights lead them. But these things, I think, are matters of degree in certain arenas where, as I think, again, through Justice O'Connor, she was always looking for that middle ground, common ground, and that may say, again, suggest a Solomonic kind of compromise, but it may very well be that there's solid jurisprudence to be had there if one thinks of it long and hard enough. And therefore, in Ayotte versus New Hampshire, the illustration I would give in the parental notification in the abortion arena, really two values seem to be driving the court. One is the judicious use of the injunctive power. So just think of your remedies course. Injunctions need to be narrowly tailored. There shouldn't go farther than the injunctive need is required. Moreover, the value of federalism and allowing the states to regulate in this very sensitive arena, because that was part of the Planned Parenthood versus Casey compromise in 1992. That the great compromise of Casey, great in the sense of large, was that the core holding of Roe versus Wade would be reaffirmed and adhered to by the court. But the states would be allowed considerably greater latitude to regulate in this area, waiting periods, information requirements, parental notification, and the like. It was no longer, as it were, a cordon sanitaire that cannot be regulated at all, or that strict. This is very key jurisprudentially. My constitutional law students will understand this. Strict scrutiny no longer applies. Does it? No. There's a sort of intermediate style scrutiny called the undue burden test. It's an unusual test. We know it from Dormant Commerce Clause analysis, and it's a balancing test in Dormant Commerce Clause, costs and benefits. We know that, Pike versus Bruce Church, right? Do we know that, guys? Yes, we know that. So there was an importing of that methodology into the arena of abortion. But the idea seemed to be the states are going to be able to regulate much more freely than was the vision of Justice Blackmun and Justice Stevens and Justice Brennan and Justice Marshall. They closed the door on that. And I think that Casey was the hoped for compromise, which then, of course, fell apart in Stenberg v. Carhart when Justice Kennedy, and if you read his dissent in the Nebraska case, you will see that he is one of the members of the plurality in Stenberg v. Carhart felt jurisprudentially betrayed. It's a very, unusually for Justice Kennedy, strongly worded, impassioned dissent using extremely muscular language. You might say, was that really Justice Kennedy speaking? It sure was. Read it again. It's not a misprint. So, an overlong response to a very straightforward question. Yes?
Do you have the same concern about the perception of activist judges that Sandra Day O'Connor has been expressing?
The question was, do I have the same concern about the perception of activist judges? In fact, the dean and I were chatting. The dean just participated in a very important conference in Washington, D.C. on the independence of the judiciary that Justice O'Connor and Justice Breyer were instrumental in organizing. We'll make this last question, so I'll keep this brief. I know people have classes and other commitments. The short answer is I believe that judicial independence is at the bedrock of our system, CEG, Hamilton's Federalist 78, where he envisioned a very robust and muscular judicial power. He did say least dangerous branch. He did say where judgment and not will are exercised, but he also recognized that judges could strike down laws that they concluded were unconstitutional. And when judges do that, some people are going to get very, very angry. And here, it seems to me that it's very important for the legal academy, for thoughtful members of the bar, to rally around our judges and to say, however, okay, you think that was an activist decision? Fine. Criticize it, urge its overruling, but cease and desist from calls for impeachment or other kinds of punitive and draconian measures against the judges. That I feel very strongly about, and I think on that most people of goodwill certainly should agree. Thank you very much. You've been very hospitable. Thank you.